hide out.
Sure. All right. Good afternoon, ladies and gentlemen. Welcome to the Case Western Reserve University School of Law. My name is Avidan Cover. I'm the director of the Institute for Global Security Law and Policy. I'm delighted to introduce today's lecture on the Foreign Intelligence Surveillance Act and the Foreign Intelligence Surveillance Court to be delivered by Judge James Carr. When Judge Carr finishes remarks, I invite all of you to come around and join us in the rotunda for some refreshments and perhaps extended conversation with the judge. Shortly after the 9/11 attacks, the law school created the Institute for Global Security Law and Policy. The Institute is part of the law school's highly regarded international law program. Last year, we launched the world's first international law massive open online course, a MOOC, which is taught by Dean Michael Scharf and has enrolled over 50,000 students from 137 countries. Since 9/11, our school has held many a session and symposium on a variety of topics related to national security and civil rights, including detention, torture, military commissions, and presidential powers. For some, the fact that today's talk is being delivered at all may call to mind Yogi Berra's oft-quoted phrase, "It's like deja vu all over again." It was not even 5 years ago that this institute actually hosted an all-day symposium titled "Somebody's Watching Me: Surveillance and Privacy in an Age of National Insecurity." Clearly, our efforts here to educate and elucidate on these matters have not resolved the seemingly perpetual and perhaps intractable struggle to balance the concerns of national security and civil liberty, and in particular privacy. This is a long balancing act. Well, today our lecturer is an especially well-qualified individual to lead us in a discussion of these issues, and in particular the Foreign Intelligence Surveillance Act and its court. From 2002 until 2000, Ohio in 1994, and he served as chief judge. Following graduation from law school, Judge Carr practiced law in Chicago until 1970, a 2-volume ed which was published in the New York Times this past. Please join me in welcoming Judge James Carr.
Thank you very much. It's a pleasure to be here. Just to give you a little sense of where I'm headed, I'll talk a bit about the constitutional and framework for the Foreign Intelligence Surveillance Act, then talk about the statute itself, its origins, what it authorizes, how it operates. The court established under the Act, the Foreign Intelligence Surveillance Court, again, sort of some nuts and bolts about how it operates and what it does. And then we'll talk a bit about, to the extent that people want me to, about any other matters of interest or concern relating to foreign intelligence surveillance and foreign intelligence gathering. And that is the basic subject, is foreign intelligence surveillance or gathering. In other words, it's the effort by our government to ascertain what people either active overseas or who are active in this country on behalf of either a foreign government or a foreign-based terrorist organization might be up to. It's not based upon criminal activity. It's based rather upon the interest of American national security and principally security against foreign-based threats. To start out with, I think it's important to keep in mind that the Foreign Intelligence Surveillance Act, which is much of what I'll be talking about today, lies in what I refer to as a constitutional shadowland. If you read the Constitution, the Fourth Amendment says that no warrant shall issue but upon probable cause, and specifically stating the place to be searched, and particularly describing the place to be searched and the thing or person to be seized. That's the Warrant Clause of the Fourth Amendment. It is there because the colonists' experience with unbridled and warrantless searches by customs officers and others before the Revolution. And so the Warrant Clause embodies a couple of principles. Number one is that privacy in that era, of course, that meant as Justice Scalia has reminded us in the GPS case, trespass, it was a property concept. The idea that the king's officers couldn't enter your private premises unless a judge had made a decision independent of the law enforcement officers that there was probable cause that a crime was being committed or other probable cause to believe that contraband or evidence would be found on those premises, and particularly describing the place to be searched and the thing or person to be seized. Fourth Amendment. Article 2 of the Constitution is that article which endows the presidency with his authority, and of course among his responsibilities is to protect us, to conduct our foreign affairs and protect us against foreign-based threats. And if you read Article 2, nowhere in that article do you find the word judge or judicial review to be present. The Supreme Court has yet to decide whether or not, indeed, when the president engages in activities, surveillance gathering or anything else, drone attacks, whatever else, that involve an exercise of his Article 2 powers to protect our national security from foreign-based threats. The Supreme Court has not determined, and nobody knows, whether in fact it is constitutional in light of Article 2 and the exclusive grant of authority it gives to the president to interpose a judge, however modestly and nominally and infrequently, into the decisions that the executive makes. But on the other hand, viewed from the standpoint of the president himself, nobody knows the extent to which the Constitution and the Fourth Amendment indeed requires him to submit, in some circumstances, to review by an Article 3 judge of those decisions. The lower courts have found the statute constitutional, but none has really answered the core question, which quite candidly, I would like to think none of us want answered definitively, whether by this court, whatever reviews are of it, or by another court, let's say the Warrant Court. I think we're all better off with the uncertainty as to just whether or not, from a constitutional perspective, in fact, the Foreign Intelligence Surveillance Court is constitutional, and whether its judges perform a function that is constitutionally acceptable. The Foreign Intelligence Surveillance Act was created in the 1970s following disclosures primarily in front of the Church Committee of widespread abuses in the name of domestic or national security by the then current and preceding administrations. I'm sure you're all aware of the now established fact that the FBI devoted substantial resources to both infiltrating and conducting surreptitious surveillance, electronic surveillance, wiretapping and bugging of civil rights leaders, including Dr. Martin Luther King. Prior to that, of the Mafia, the Cosa Nostra, under Bobby Kennedy, and as well of foreign agents and representatives. This caused a very substantial furor, and prior to that, in 1971, in U.S. versus U.S. District Court, the Supreme Court had held that the Justice Department, the John Mitchell Justice Department, had violated the Fourth Amendment when it conducted, without prior court order and without going to a judge, and in violation of the Fourth Amendment, electronic surveillance of a group styling itself as the White Panthers in the Detroit, Ann Arbor area, which some of whose members were suspected of having planted a bomb outside the CIA headquarters on Main Street in Ann Arbor. John Mitchell said that in the interest of, quote, domestic security, he had the authority under Article 2, stemming from the president, to engage in that kind of activity of an American citizen in the United States without a warrant. The Supreme Court held, no, that's not so, that if the government cannot conduct surreptitious electronic surveillance unless it has done so in accordance with a statute which in the meantime had been enacted, the Title III of the Omnibus Crime Control and Safe Streets Act of 1968, which authorizes law enforcement surveillance upon the showing of criminal activity, probable cause, conventional probable cause, about criminal activity, and that the surveillance will uncover evidence of a crime. That's Title III, and I may from time to time refer to that. When I do, I'm talking about the use of wiretapping, bugging, electronic surveillance, i.e. of email traffic, internet traffic, and so forth, for law enforcement purposes. That's under the aegis of Title III. That's clearly constitutional, quite candidly, fairly routine and commonplace throughout the country, particularly in investigations of organized crime and so forth. In the U.S. District Court case, the Supreme Court said quite expressly, we're not talking about surveillance that focuses upon our foreign security, our security against foreign-based threats. That's up to Congress. Congress did not accept that invitation until the Church Committee hearings, and thereafter it enacted the Foreign Intelligence Surveillance Act, which in turn created the Foreign Intelligence Surveillance Court. FISA for the statute and FISC for the court. The court began operation in 1978. At that time, it had 7 judges, district judges, each of whom is appointed at the sole discretion of the Chief Justice of the United States. There's no senatorial consideration or confirmation or even presidential involvement at all. It's solely an authority that the Chief Justice exercises. The Patriot Act of 2001, adopted in October, shortly after September 11th, increased the court from 7 to 11 district judges. I happen to be one of the ones that got an appointment for a newly created position. The judges now serve staggered terms to start out with, but now it's a 7-year term, non-renewable. By statute, the judges must be geographically diverse, though 3 of them must live within 20 miles of the capital. The statute authorizes the government to go to the FISC, the Foreign Intelligence Surveillance Court, upon a very, very modest showing of probable cause. It's one of the things I want to emphasize, that if the government shows probable cause as provided in the statute, the judge must issue the surveillance order or a search warrant, whichever it may be. Talking primarily, of course, about surveillance orders. The judge has no discretion. Can't second guess whether or not it's useful or perhaps even potentially embarrassing for our country if word of the particular surveillance got out. All the government has to show is that it meets the probable cause standard. If it does so, the order then issues. There are 2 different kinds of orders, and I'm going to talk primarily about one kind. The first kind is directed at agents or representatives or persons acting on behalf of a foreign government. Well, there are 2. The probable cause that needs to be shown is probable cause to believe that a person, the target of the surveillance, is acting on behalf of a foreign government or is affiliated with a foreign government or institution. That person can be foreign-born, native-born, doesn't matter. The persons whose communications are being protected by the order would be that individual's communications only if he were an American citizen or lawful resident alien, which would rarely be the case. The communications sought to be protected are those that come to that person from U.S. persons, American citizens or lawful resident aliens. Those are the people whom the statute seeks to protect. And those surveillances run for a year. And again, I think you can well imagine. Let's assume for the moment that the commercial attaché for the Kingdom of Xanadu here in Cleveland, which of course neither the position nor the kingdom exists, that's the slot succession. That's where the Xanaduians put their spies to go down and check on the Lima tank plant and Norfolk Southern rail traffic, et cetera, et cetera. And that simply is very routine. They would come and say, Judge, here's the evidence that we have that this is where the Xanaduians put their spies, and that surveillance will be authorized for a year and basically gets renewed and continues. The other kind of surveillance, and that used to be the principal focus, of course, of the surveillance, the FISC's activity, and the vast majority of the applications involved counterintelligence, counterespionage, finding out what foreign governments are up to or what kind of dangers they may present to us. particularly since September 11th, but even before then, but especially since September 11th, it's the second kind of target that, of course, has occupied the court and public attention substantially, and that is persons who are either affiliated with or working on behalf of a foreign-based terrorist organization. That is the second category of person as to whom a FISC order can issue, or a FISA order can issue. And once again, the probable cause, I want to emphasize this, is a very low standard. It is basically to show that the particular organization is a terrorist organization, and there's a list of dozens of specially designated terrorist organizations, and once that name is in there, and then the second thing, and the probable cause has to be shown, is that individual is acting on behalf of or affiliated with that particular foreign-based organization. It does not require a showing of criminal conduct, unlike an ordinary Fourth Amendment search warrant or a Title III law enforcement surveillance order. It's simply the connection, it's the affiliation, it's the relationship. And that's it. Once that is shown, then that surveillance can be conducted. It can be wiretapping, landline, cell phone, internet traffic, anything dealing with a computer, oral communications. I'm giving an oral communication now, another spoken, picked up by a microphone or a bug. And those are principally under the overall rubric of electronic surveillance or surveillance generally. And and that's all that has to be shown. Now those surveillances can run for up to 3 months, and then the government can apply to have them be renewed. Once again, when the government comes in, it need only show continuing or prospective probable cause. This is not a situation where a Foreign Intelligence Surveillance Act court can sit down and say, well, how are you doing? What are you learning? Is it really worthwhile? Unlike the situation with a law enforcement surveillance order, where every week, when I issue a Title III order for a drug ring, FBI, DEA, I meet with the agents every week to make sure that there's continuing probable cause, that the surveillance is not turning up nothing, because if it is, that raises a question. Notice I have a colloquy on the record with them, ex parte, to find out how they're doing. That is how the concept of judicial oversight and control, which is at the heart of the Fourth Amendment, remember the Warrant Clause, that's how in the context of an ongoing electronic search is controlled in the law enforcement context. Because I meet periodically, regularly, I make sure that the conversations are being properly minimized. That is, that they're only listening or undertaking to listen to those things that are pertinent, involving co-conspirators, involving subjects of the investigation. And so there's ongoing judicial oversight. And there may be times when I'll say, you know what? Doesn't look like you're getting a whole lot. I'll let you go for another week. And quite often, it is they who come and say, Judge, they've dropped the cell phones, there's been no activity or whatever, they shut it down. Sometimes it keeps on going, and they renew it. But in the law enforcement context, just as in the ordinary search warrant context, particularly describing the place to be searched and the thing to be seized, there is a restriction on the extent of the intrusion. Remember, the other part of the Fourth Amendment is the prohibition against general searches. That's why they have to particularly describe what it is they're looking for, where they can look, and what they can take. That's so that, unlike the customs officers who would go into John Hancock's warehouses and take out everything, under our Fourth Amendment, law enforcement officers can only go in, look for specific things at specific premises, and then they have to leave. That's because the Fourth Amendment embodies at its core a prohibition against general, sweeping, unrestricted searches conducted solely, the scope of which, once they're inside the doors, or the scope of which is controlled only by the officer's curiosity and discretion. Fourth Amendment is quite clear. That is prohibited. Those of you who take criminal procedure, I trust, remember that fundamental doctrine. So two things. Ongoing judicial control, issuing a search warrant, they come back with an inventory, they tell you what they've taken. The subject knows right away, hey, my house is busted into, my car has been taken, whatever it is. Title III, the drug case, crime, they don't know when it's going on because it's secret, but if they get indicted, if they're named in an order, they have to be notified that they were named in an order. If they get indicted, they get access to the evidence. And also there's ongoing, sort of the judge rides shotgun in a law enforcement situation. Not so in the FISA situation. As I mentioned, well, first, there's no intervening review. I issue the order for 90 days. When the Bureau comes back, or the NSA, or whatever the Department of Defense, or whatever the agency is that comes back, it's probably before some other judge. And that judge is looking only ahead, not back to how effective or whether or not that probable cause was adequate. It's looking ahead. Probably most significantly, in terms of so there's no ongoing judicial control. The judge is interposed at the outset, but not thereafter, only when they come back and want to renew it. And the same is true with the searches directed, the year-long searches directed at governmental agencies or entities, or agents thereof. The other thing that is significant about a foreign intelligence surveillance is that it is a general search. Everything is recorded or taken in. I mean, if it's email traffic, everything, all those emails will be downloaded. Internet traffic, all the keystrokes will be subject to observation. But what happens, and the term minimization has kind of a unique meaning in the FISA context. Whatever the take is, whether it's an optical scan disc of a telephone conversation or whatever the form or format in which the digital information is gained, it's reviewed quite quickly thereafter. Because one of the things about intelligence information of the sort they're trying to get, it often has a very short shelf life. You're not looking at it to gather evidence of a crime. You're trying to find out what people are up to. And so it is looked at promptly thereafter. And I don't know what they do with digital information, but with telephonic information or other kinds of recorded spoken conversations. It's recorded on some kind of, it used to be optical scan disc, they have probably something even more fancy than that. But the intelligence officer would review on a daily basis yesterday's take, noting the places in the recording, the number or whatever, where something's pertinent, and making a note of whatever that is. Then that disk goes off into storage. Even though everything may have been intercepted at the outset, as a practical matter, all that is available to the government is what was noted early on as being useful. Now, there may be, at the end, I may talk a bit about some question I have about that, but in any event, as a general rule, it sort of disappears, truly disappears. So, no ongoing judicial oversight, a general search, everything is acquired automatically. There's no continuous listening the way there is with a law enforcement wiretap, as by necessity, because they have to turn it on and off so they don't listen to things that they shouldn't be listening to. And then finally, the likelihood that anybody who was a target or intercepted through a FISA warrant, that you would ever know about it, is almost nil. Because there is no requirement, as there is with an ordinary search warrant, the inventory requirement, there is with a law enforcement wiretap, the post-surveillance notice. The target is never notified. Those with whom the target communicates are never notified, unless, and in a very rare circumstance, where a decision is made that the target of the intelligence gathering is in fact not only affiliated with, let's say, a terrorist organization, but in fact has gotten engaged in criminal activities and winds up getting prosecuted. When there was a FISA take is transferred from the intelligence side of the FBI to the law enforcement side. And that's a fairly rare phenomenon. In that instance, and I've had 2 cases in Toledo, and I know at least one here in Cleveland, where people were charged with activities in support of overseas terrorism. One of mine involved a plot, I suppose, between a husband and wife to ship $1 million to Hezbollah. Of course, they didn't realize at the time the $1 million was going to be our money provided by the FBI, which wasn't going to go anywhere, and which it didn't. But in any event, that's one sort. And another one involved 5 persons charged with conspiring to basically, the gist of the conspiracy was that they were going to become trained. The trainer was an FBI informant, passed off to him from DEA, who purported to be an African-American convert to Islam, and basically the conspiracy was created and they were found guilty. But even then, even if part of the information that the government had about those now 7 individuals had its origin in a FISA order, they would not know, unless, under the Classified Information Procedures Act, their attorneys filed a motion, as they did in my cases and do routinely in these cases, demanding the production of any and all evidence derived from foreign intelligence surveillance orders under the Foreign Intelligence Surveillance Act. There's a barrier to that, though, under the Classified Information Procedures Act, because the government has the opportunity to come in and say 2 things. Yes, or no, judge, this is all under oath, no judge, there was no FISA order. Or yes, judge, there was a FISA order. This is what we learned, and this is the evidence that we have and how and where we got the evidence. Usually in these domestic terrorism cases, there's almost inevitably or always an FBI undercover officer, 1 or more. If you read the papers, I think you'll see that that's a commonplace circumstance. There's vast amounts of consensual recording by the informant, consensual video, video surveillance of public places and so forth. Those ordinary conventional investigatory techniques have provided the vast majority of evidence in the vast majority of cases. Once in a very great while, the government will say to the judge, yes, judge, we agree that you must disclose this, that, or the other thing as being derived from a Foreign Intelligence Surveillance Act order, and here are the orders. They become available to the defendant, but that's extremely rare. Almost never happens. So no continuing judicial oversight, general search, no post-search search notice under the Foreign Intelligence Surveillance Act. Every Court of Appeals, all of them very early on, to consider the question of whether or not this comports with the 4th Amendment, which is the way the issue came up, people who've been indicted, has upheld it. Because of the fact that of the zone of presidential authority over which Congress has authorized the judiciary to provide a modest measure of oversight. The oversight is at the outset. As you probably are well aware, the instances in which a judges like myself in the Foreign Intelligence Surveillance Act Court, have turned down government applications because there was no probable cause are very, very few, a matter of a few dozen. Interesting since 1978. Maybe more than a few dozen now. I haven't checked the statistics for a while. Interestingly, there have been fewer turndowns since 1968 of Title III law enforcement wiretap applications, the kind that I see not day in and day out, a couple times a year in my court, maybe more or less, with the FBI or DEA or ATF or whatever. There have been fewer turndowns of Title III applications than there have been of FISA applications. Why might that be? Is it because we're a rubber stamp? Because we don't care about the Constitution? We're so phobic about terrorism and the Xanaduians and all those other bad people out there that we say, where do I sign? I suppose all I can do is say, trust me. But that's not the way it works. And let me give you a little bit of how these applications work. They begin with an officer, an agent, let's say in the FBI. It could begin here in Cleveland. I assume that ever since September 11th, about half the FBI's assets have been devoted towards counterterrorism, the other half towards the kind of conventional criminal, drugs and bank robberies and so forth that historically have been under the purview of the Bureau. If an agent here develops what he thinks is an informant or reason to believe that somebody is acting on behalf of a foreign terrorist-based group, he cannot simply go to a prosecutor here and say, as he can with the Title III order, start the process. Those two have to be approved in the Justice Department. He has to go within the agency and he has to persuade the agency that this is a potentially valid and worthwhile investigation. Then it would go from the resident agency here in Cleveland to the Hoover Building in DC, across the street from the Justice Department. And only then, and I'm led to believe, and I think it's probably true, that it's a relatively rare instance in which requests make it that far and get the approval at the highest level of the FBI. Then the applications are prepared by FBI lawyers, and they then go to what used to be called the Office of Intelligence Policy Review. That was the unit within the Justice Department, and it's now under the Director of National Security. I don't recall its current name. But the unit of Justice Department lawyers who review the applications that come in from the various agencies. NSA, FBI, Department of Defense, and so forth. State Department. They, in turn, perform a gatekeeping function. Then, once they agree to submit the application, by rule of the Foreign Intelligence Surveillance Court, and that rule codified the practice, by rule of the court, the application must be submitted, I'm using the term submitted deliberately, to the court, given to the court, the clerk's office in the court, set not later than 7 days before it's presented for judicial review and consideration. So submission versus presentation. In that period, a cadre of, and the title is legal advisors, one or more of them will review each and every application, and there are several dozen per week, but fewer than 100, at least when I was there. And these figures are all known. I mean, there's nothing secret about them. When I started, I'd have maybe 20 to 25. When I was done, I had maybe anywhere from 45 to 60. OIPR, the Justice Department unit, went from 20 lawyers to 120. We had one legal advisor, and when I left after 6 years, there were 5. So it gives you some sense. It's all post 9/11. But the legal advisors perform a crucially important role. They are thoroughly experienced. They work for the court. They're not magistrates, but they're not law clerks. Someone asked me earlier if one of my law clerks who came over with me would work with me on FISA. No, and I don't do it at home. You go to Washington. Everything is within literally an enclosed but now attractive chamber in the district court in Washington. But not infrequently, I would show up on a Tuesday morning and be told, Judge, this case is off docket, that case is off docket, the other one is off docket. Not a whole lot, But my point simply is, a certain number of those cases never get formally presented. They never get formally presented because the legal advisors have raised questions about them. There were instances in which I would review an application, let's say, because then what happens, you show up and you've got stacks of paper to read, and these applications are very lengthy. These are not your 2-paragraph municipal court search warrants. They run anywhere from, I think I would say probably the shortest would have been maybe 40 to 50 pages. They run 80 to 100 pages routinely and sometimes more than that. Sometimes they read like a Tom Clancy novel, a John le Carre novel. Much more often they are really quite, they are all fact-based and the facts are there. And they say, we have no discretion. But sometimes I would read it. The legal advisors always give a short memo, looks fine, no problems, or whatever. Also by rule, and now I'm finally getting the heart of the proposal I made, which codified prior practice when the rules were adopted in 2008, the government, when it is going to do something that's new or novel, unusual, that it hasn't done before, some kind of method, means, technique, approach, target, whatever, something that is pushing against the envelope, it would, and since the rules are there, must notify the court about that fact. And that's what the government would do. Come in and say, Judge, or tell a legal advisor, Judge, you really should look at paragraph 68 to 84 or 72 or whatever it is. This is something new and this is how it is new. On a couple of occasions when I had that, I actually went to various places to eyeball it, to find out what it was they were talking about. And at that point, I could really talk to anyone or do anything I wanted to make sure that I was comfortable if I was going to issue the order that indeed it was statutorily acceptable. That's the test. Is this statutorily acceptable? Well, as well, of course, there is the issue of the Fourth Amendment, but the question really principally was statutory suitability under the statute. And from time to time, I would raise questions, and the application would never come back. That wouldn't be registered as a turn down. It wasn't a rejection. I'd simply say, look, tell them I think I need some more information about this or that. But that doesn't get, that disappears. That's what the Germans call a Dunkelziffer. Nobody, and so one of the proposals I made is to say, look, there ought to be, you ought to record the instances in which applications are submitted but never presented, presented but never formally ruled upon, basically withdrawn, and once they've been presented to a judge, they must go back to that judge. If I raise questions that they don't want to bother answering, they can't simply come back next Monday to the next judge. Again, by rule, there's no judge. By statute, I think there's no judge happening. Once presented to a judge, if it's, that judge is raised, and occasionally that happened, and I would go back and handle it flying and out, take care of it, and be done. But I would hope that those numbers would be, they could be generated, and I would hope that they'd be publicized because it would show the fact that the court, in fact, is operating in the way that it should. In a context of, as I say, I mean, so many of them, there's just no question. You read the heart of it. A lot of it's boilerplate, but you read the heart of it, the probable cause part, and it's there. And one thing I learned, I think I can say without running risk of becoming indicted for disclosure of classified information, is quite simply some of our enemies are. There's no question about that. And there's some people and entities and institutions out there who, want to cause us and our society, our country, and our democracy serious and grievous and permanent harm. And so the other suggestion that I made, and I think about 1 more minute for the 20 minutes of questions. The other suggestion I made, which actually sort of got me involved in the conversation, was in early July, the New York Times had a lead editorial about how the Foreign Intelligence Surveillance Court should publish its opinions. I happen to agree with that. It had done so on 1 or 2 occasions in the past. However, I write more opinions in a week in Toledo on employment discrimination and police misconduct and contract cases than I wrote in 6 years on the Foreign Intelligence Surveillance Court. You don't write many. You only write them when there's some reason to do so. And because, just like with a search warrant, judges never write opinions when they issue search warrants. They never write opinions when they issue a Title III order. The question is probable cause there or not. In the FISA context, however, because from time to time there are new and novel methods and means and technologies and approaches that, in fact, are called to the court's attention, which do raise questions and which result from time to time in opinions. Reading that editorial, it occurred to me that perhaps, well, it seemed kind of audacious for some guy in the backwaters of Maumee to contact the Imperial New York Times and say, publish this. Well, so I wrote a piece on a proposal, which quite candidly I'm pleased to see, not just on account of me, is gaining, I think, a fair amount of traction. And as my suggestion was to give the judges, the individual judges, the discretion to reach out to a pre-security cleared lawyer, to have that lawyer come in and advocate. One way I refer to it is on behalf of the Constitution, on behalf of privacy interests, on behalf of the Fourth Amendment. In any event, to have a lawyer who could come in, and if that lawyer felt arguments were there to be made, and that lawyer might not, might conclude, Judge, I thank you very much, but I really can't, there's no argument I can make plausibly and in good faith. On the other hand, if that lawyer did, that would give me the benefit, because the judges in that court are dealing in uncharted territory. Nobody knows when the government has come in and said, we want to do X. We want to collect all the metadata of all the cell phone traffic in the country, which is what the PRISM program is all about. And I could see, I wasn't the judge who was there for that. That's after my time. But that's exactly the kind of situation, it seems to me, that the public interest, the interests of the court, and its public view of its integrity and commitment to the Fourth Amendment principles could be upheld. It would introduce, it would bring another set of thoughts into the courtroom, and that's the way we judges work. Though never in the context of a search warrant or a Title III application. That's one of the objections. My God, you mean you're going to let some lawyer come in? You're going to let the ACLU in there then? And I say, yeah. Why? Because, as I mentioned earlier, there are no handholds to challenge a FISA order unless somebody gets indicted. And that's very rare. And even then, all of that has to be disclosed. And that's not the kind of situation or setting that I'm talking about, that I would believe, quite candidly, that having an independent lawyer there. The other thing that would do is that would give the opportunity for appeal. There is an institution called the Foreign Intelligence Surveillance Court of Review, 3 appellate court judges, appointed as we are, I believe, for 7-year terms, rotate, non-renewable appointments. Because obviously, if I grant the request, the government's not going to appeal. It's happy. And it's only if I deny the request, which happened once, and this happened right after it was on the court. It's all you can look it up in the FedSup and FedSecond, first reported decisions. Went to the Federal Court of Review, and there was nobody there speaking on behalf of the denial. It was simply the Justice Department lawyer in a secret proceeding, ex parte, telling 3 appellate judges why district judges, the district judge or the FISA court made a mistake. And so as I say, it would provide an avenue for appeal, and ultimate might provide an avenue from time to time for Supreme Court review. And that's basically the gist of what I've proposed. Others have proposed more elaborate. Senator Blumenthal, among others, has proposed the appointment of, quote, an office of special advocate, which would vet each and every one of the FISA applications. And in my view, that is both unnecessary and cumbersome and too expensive, because that is what the legal advisors do, and that is what the judges themselves do independently. And to interpose another layer of bureaucracy in that vast number of cases where there is nothing to do would, in my view, make no sense. So my proposal, and I've actually changed a little bit, instead of making it discretionary, simply whenever the Justice Department invokes what's now Rule 11, that is, this is something new and novel. That's a trigger. But you could have a small panel of pre-cleared attorneys who become knowledgeable in this area, experienced in this area, and I think, as I said, it's a very simple, very modest proposal, and I think I will end there. I could talk. Now you've heard the first quarter of my speech. If you want to stick around for the last 3 quarters, I'll take questions. I'm here for as long and glad to do so as much as you want.
Okay. Sure, please,
Yeah.
if you have questions, if you can come up to a microphone.
Yeah.
It's being broadcast, so we can hear your questions.
The only thing I've got to tell you, you disappoint me, because usually when I talk to lawyers and law students, the front rows are empty, and I tell you how welcome you make this former law professor feel by sitting as far away from me as you can. So I'm kind of heartbroken I didn't get to use that line. Yes, sir, go ahead.
Relevant to the excesses of the what was determined within the church committee, the Red Scare, McCarthy era, do you feel there's sufficient oversight? And what is the litmus test in terms of a reason to believe, or in terms of probable cause? And how does that ferret out? And what is the litmus test and legal standard for that in terms of these indictments? And the information, like you said, you had went out one time, make sure things were okay. How do you ascertain what is okay, and how is that defined in the legal mind?
Well, I'll tell you a true story about that. Without going into any detail, I had a question about the ability of the government, its attorneys and others, to access the storage areas where the disks were kept. And I went to the particular FBI office. It was rather daunting. I was rather high up in a skyscraper. I sat as near to the door as I could, rather than my back to the window, about 28, and they weren't happy to see me, but basically I insisted on seeing. And I mean this truthfully. Went down into the area. It sounds facetious, but it's true. I met the woman who was in charge. And I had an opportunity to talk with her at great length about the safekeeping procedures, how nobody without prior authorization could get past her, could get their hands on a disk. She was the gatekeeper. And what gave me more comfort than I can express, that woman reminded me nothing quite so much as my then recently passed away Irish Catholic New York City mother-in-law. And seriously, she was determined. And that gave me comfort. I mean, I think one of the things that people should understand, when I became a magistrate judge in 1970, I'm a child politically of the 60s, I was suspicious of the FBI. It didn't take me long to realize, to handle very many search warrants, and I've been doing it now since 1979, since half this room was born, before they were born, to become persuaded that there is a degree of dedication that we do not give people of that sort credit for. It's a rule-bound agency. It's a bureaucracy. And if you persuade a judge to issue a warrant that does not have probable cause and that evidence gets suppressed, that is not a career-enhancing move for an FBI agent or an ATF agent or a customs agent or whatever. Well, when I went on the FISA Court, and I'd been the author, as indicated, for more than 20 years, or a little more, I guess 25 years, of a treatise on electronic surveillance, and it covered all the FISA cases. And I was as suspicious as any one of you in this room is about that court, what it does, and most importantly, about the government's intelligence gathering activities and functions. And I think that kind of skepticism and suspicion is at the core of a healthy democracy, to be concerned about what they are up to and what they're going about. However, candidly, somewhat to my surprise, and I'll be very honest about that, in the passage of time, as I began to work with people, I understood they have the same degree of dedication to doing it within the statute and the Constitution that you would hope any government official would have. And the other thing about, sitting there as a FISA judge, FISC judge, one is conscious of two things. I don't want to be a judge who turns one down and a building goes up. On the other hand, I don't want to be a judge who shreds the Fourth Amendment yet a little bit more. And the question of oversight, sort of answer your question
Right.
directly, is to date, under our government, the principal means of oversight is through Congress. And if it has not done its job adequately and properly, then it is the fault of Congress. Because what the judges do in the Foreign Intelligence Surveillance Court involves a small slice of the overall intelligence gathering activities.
Okay, last time I'm gonna go sit down. The exculpation process, given the gravity of the charges or indictment, is there transparency in exculpation in this process? given
Well,
gravity
the
of
only,
charges?
in the federal system, the only quote exculpation is a not guilty verdict or dismissal. There's no expungement in the federal system.
I'm talking about prior to exculpatory, that's what I mean, exculpatory.
You mean considering contrary evidence?
Yes, exculpatory.
Well, it's hard to say because what I got is what I saw. So I can't say what wasn't there.
But how do you refute if they accuse?
Well, because I don't. That's not my function. As I said earlier, my job under the statute is simply to determine whether probable cause is there, reasonable cause to believe. It is not to assess the validity, the desirability, the utility of the activity.
Okay.
Yes, sir.
Judge, when you were serving on FISC, were you relieved or did you have your duties scaled back on the district court?
No.
And did you have to swear a supplemental oath, such as a CIA or FBI agent would, as to secrecy?
No. I did have undergo a sort of wall-to-wall background check. I probably shouldn't say this, but when I was told that congratulations, you've reached the highest security level. This is in 2002. Quote, you now can know as much as the president. And I'm sorry, I couldn't resist saying, is that all? Is that it? All that for this? Smart aleck.
Thank you.
So you can delete that from the record, please. Yes.
Judge Carr, at the outset, you said that there were some important constitutional questions in this arrangement that you thought would be best left
Right.
unresolved. Could you say a few words about
Well, and I alluded to them, I can summarize very briefly. Do we really want to find out whether or not the Fourth Amendment plays a role in this area at all? Because once that decision is made, if the outcome is, and I think we can see a court saying that no, Article 2 is exclusive. It's a violation of the separation of powers. For Congress somehow to say to judges, go in and vet what the executive is doing. On the other hand, I suppose another court could well say, make far deeper intrusions under the banner of the Fourth Amendment. And I mean, I feel, I don't try to answer your question. I mean, that's the problem I see it. I personally, as a citizen, I don't want those lines drawn by anybody, whether it's Earl Warren or John Rogers. I mean, I just don't want that line defined, because the FISA really represents a tripartite compromise between the three branches of government. Congress has given us, the judiciary, this authority in a limited way. And, as importantly, the executive has accepted it. One of my concerns about some of the proposals that are being made in the name of oversight and otherwise, even a President Obama might say, hell no, I'm not going to do that. You are touching upon my executive authority and the office of the presidency, sue me. And again, once again, the executive has not taken that position. In fact, the executive, again, this is going to come as a shock to you, perhaps, some of you, is very supportive of the FISA Court. It wants it there. Why? Because when there is a prism, the court, we got judicial approval. We went and met the statutory requirements Congress has imposed, which they did. And so don't jump all over us. And I hope it's a compromise that maintains. And more questions, I'm more than glad to stay until I get kicked out. Yeah, yes, sir.
Judge, one question about the metadata program.
Okay.
The Section 215 warrants that have been issued. In some ways, I think to many, why that was so distressing, right? The collection of essentially all Americans' phone information, is that would seem, at least at first blush, beyond the purview of foreign intelligence information.
Okay.
How does that square sort of with the the overall mandate, if you will, of FISA? And what do you say to, I guess, many Americans' discomfort?
Well, yeah. I think one can argue about the wisdom from a policy standpoint. However, the focus of that collection is on traffic between an American cell phone or a foreign cell phone that may be routed through the United States. But it begins with a foreign telephone number. And I think a couple of things. I mean, it may be troublesome that the government, when I just got a call from somebody, that, you know, that fact that whatever that number was to my number got soaked up and is stuck in some vast computer. And that's true for all of us. Keep in mind, however, that what the government is trying to do is, in fact, to determine predicate information, precursor information, initial indicia with this program, initial indicia of some foreign-based connection. They're not going to pick a number in South Yemen or, you know, the tribal regions or elsewhere. They're not going to simply pick numbers willy-nilly. They will, this is my assumption, okay? And it simply makes sense to me. They will have a number from somebody about someone who has some connection or is using that phone for some purpose. They will then check to see what, this is the first hop, what numbers has that number called? And they will sift through those numbers, and then if they find another one. The real concern, I think this is a fair concern, was how far does this go? I mean, how many degrees of separation until they get 419-787-9936, my cell phone number? Who knows? Okay. But candidly, and I speak as a citizen, I truly am not concerned about that. They're not listening to what I say. They're not creating a mosaic, which is a term that they use, about my conduct or my contacts. Could they? Sure. Are they? Absolutely not. I mean, it just, there is no, and I think for all but the tiniest sliver of a fraction of a percent of the population of this country, those numbers have gone into some vast computer and are there. I do think, and I do agree with the government on this, if the program is lawful, and the FISA court has held that it has, a district court has held that it is not, another district court has held that it is. So we have a conflict among the districts, and who knows where those cases will go from there. However, if the program is lawful, I mean, think about this. It's like looking for a needle somewhere between here and Toledo. I mean, it's just, part of it is they have so much data. There was an earlier iteration of a similar program called a terrorist surveillance program, where they were doing something similar on email addresses. And that was disclosed in 2005 by the New York Times. Very distressing. By 2008, they shut the program down because it wasn't worth the effort to sift through what they were getting. And I can only imagine the effort today. But the most important thing is, under no circumstances is there any collection of conversation or communications, and also, I realize it's kind of a weak statement, but you know, there's simply no reason for them to, and they go 3 hops is what I understand, and there's some suggestion to curtail it. Well, one of the points, and I truly think there's no reason for any of us to be alarmed, particularly now that the program's been disclosed, its utility probably has been compromised. Think about that. That's part of the whole Snowden situation. But the idea that we should limit the government's ability to acquire this information solely to subpoenas to the providers, that it should not be kept within government-controlled computers, that could create a problem and impediments.
I have one.
Well, we're gonna close proceedings. You can ask the judge a question after. Thank you, everyone. Please join me in.
Time out. Wait a minute. I'm still a judge. Show of hands. How many of you think that what Edward Snowden did is worthy, laudable, and in our national interest? How many of you think that what he did is unworthy and contrary to our national interest? I realize equity does not love a gratuitous volunteer, but let me give you my take. What Snowden did, in my personal view, is the single most dangerous disclosure of serious national secrets in the history of our country. It's my understanding that the New York Times and Washington Post have upwards of 50,000 documents that he provided. So these revelations are going to keep on coming out. Much more importantly, our government, us ultimately, has to assume that everything he was exposed to, whether he actually downloaded it and gave it to the Russians and the Chinese, is now known by the People's Republic of China, the People's Republic Army of China, and the Russian and Chinese intelligence services. And that should not be welcome news to anybody. I mean, those organizations probably would have enjoyed spending a couple of days with me, and what I learned was probably that much of a room full of information. And our government has to assume that every single thing that he was in any way exposed to, he copied and has provided. And I want you to think about that. He's no Daniel Ellsberg. Daniel Ellsberg had the courage of his convictions. He gave the Pentagon Papers to the New York Times and stayed in this country. If he was to be prosecuted, then let them prosecute him. Mr. Snowden didn't do that. And, I mean, for me, having seen what little I saw about some very important activities, to realize that countries, we may not be at war with them, but we are hardly on the friendliest of terms with China and Russia, and perhaps others to whom they've in turn disseminated information. And the consequences, the danger to this country as a result of the fact, those of you who are lawyers, think about if every one of the lawyers on your other side had everything in your files, or if you're a corporation executive, or any of your own bank accounts. What if everybody in the world could look at your bank account, or whatever? I urge you to put what Mr. Snowden did in that context. I feel obviously very strongly about that, and I try to close these conversations with that observation. And my exposure and insight is very slight. I have talked to some people who are more directly affected, and I mean, it's just unimaginable. So, anyway, I'll leave you with that. I'm glad to stick around. Anybody's welcome to come up and talk to me again.